Check, check, 1 2, check, 1 2, yes. Test, 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 test 1 2, test 1 2 3. Ja. So you can see the light brighter than, but it will work. Hello, hello, hello. Yeah, sometimes.
Please be seated. The sitting is resumed. Mr. Salve, continue his presentation. You have the floor.
Honorable President and Honorable Judges of the Court, I resume picking up the thread where I was citing some of the literature which has come out, some of the decisions which have come out from the Inter-American Court of Human Rights. On 1st October 1999, the Inter-American Court of Human Rights rendered an advisory opinion on several treaties concerning the protection of human rights in America. As noted by the court, and I quote, according to the requesting state, the application concerned the issue of minimal judicial guarantees and the requirement of due process, where a court sentences to death foreign nationals whom the host state has not informed of their right to communicate with and to seek assistance from the consular authorities of the state of which they are nationals. The Inter-American Court analyzed the Vienna Convention and held, and I quote again, the court observes, on the other hand, that in the case concerning United States diplomatic and consular staff in Tehran, the United States linked Article 36 of the Vienna Convention on Consular Relations with the rights of the nationals of the sending state. The International Court of Justice, for its part, cited the Universal Declaration in the respective judgment. The Inter-American Court also held, and I quote again, that Mexico asking whether one provision of that convention rights. This is an important point given the advisory jurisprudence of this court, which has held that a treaty can concern protection of human rights, regardless of what the principal purpose of the treaty may be. Therefore, while some of the comments made to the court concerning the principal object of the Vienna Convention on Consular Relations to the effect that the treaty is intended to strike a balance among states are accurate, this does require that the treaty be dismissed outright as one that may concern the protection of an individual's fundamental rights in the American hemisphere. Going into this question, sir, the court holds, and I again quote, provision concerning recognizing consular communication serves a dual purpose, that of recognizing a state's right to assist its nationals through the consular officer's actions, and correspondingly that of the recognizing the correlative right of the national of the sending state to contact the consular officer to obtain that assistance. Unquote. In paragraph 82 of the judgment, it notes that the bearer of the rights mentioned in the preceding paragraph, which the international community has recognized in the body of principles for the protection of all persons under any form of detention or imprisonment, is the individual. In effect, this article is unequivocal in stating that the right to consular information and notification are accorded to the interested person. In this respect, Article 36 is a notable exception to what are essentially states' rights and obligations accorded elsewhere in the Vienna Convention on Consular Relations. As interpreted by this court in the advisory opinion, Article 36 is a notable advance over international law's traditional conceptions of this subject. The conclusions arrived at by the Inter-American Court on this issue were as follows, and I quote, the court therefore concludes that Article 36 of the Vienna Convention on Consular Relations endows a detained foreign national with individual rights that are the counterpart to the host state's correlative duties. The interpretation is supported by the article's legislative history. There, although in principle some states believed that it was inappropriate to include clauses regarding the rights of nationals of the sending state, in the end, the view was that there was no reason why that instrument should not confer rights upon individuals, and that the court must now consider whether the obligations and rights recognized in Article 36 of the Vienna Convention on Consular Relations concern protection of human rights. The Inter-American Court then proceeded to examine the question whether non-observance of the right of information violates rights under Article 14 of the ICCPR, Article 3 of the Charter of the Organization of American States, and Article 2 of the American Declaration of Rights and Duties of Man. It cited the advisory opinion of this court in legal consequences for states of the continued presence of South Africa and Namibia on the principles of construction of treaties, where this court held, and I quote, "The court must take into consideration the changes which have occurred in the supervening half-century, and its interpretation cannot remain unaffected by subsequent development of the law. Moreover, an international instrument has to be interpreted and applied within the framework of the entire legal system prevailing at the time of the interpretation. In the domain to which the present proceedings relate, the last 50 years have brought important developments. In this domain, as elsewhere, the corpus juris gentium has been considerably enriched, and this the court, if it is faithfully to discharge its functions, may not ignore." The Inter-American Court traced the genesis of the ICCPR insofar as it recognizes the right to due process of law, and I quote, "from the inherent dignity of the human person," unquote. It held that in the opinion of the court, the due process of law, a defendant must be able to exercise his rights and defend his interests effectively and in full procedural equality with other defendants. In words that resonate in the present case, the court held that in the case to which this advisory opinion refers, the real situation of foreign nationals facing criminal proceedings must be considered. Their most precious juridical rights, perhaps even their lives, hang in balance. In such circumstances, it is obvious that notification of one's right to contact the consular agent of one's country will considerably enhance one's chances of defending oneself and the proceedings conducted in respective cases. It further held that the individual rights under analysis in this advisory opinion must be recognized and counted among the minimum guarantees essential to provide foreign nationals the opportunity to adequately prepare their defense and to receive a fair trial. Citing the approach taken in a number of cases involving the death penalty by the United Nations Human Rights Committee, the Inter-American Court noticed that the view of the committee was that, and I quote, because this is extremely important, "If the guarantees of due process established in Article 14 of the ICCPR were violated, then so too were those of 6.2 of the Covenant if the sentence was carried out," unquote. Consistent with this approach, the Inter-American Court held in paragraphs 135 to 137. This tendency, evident in other inter-American and universal instruments, translates into the internationally recognized principle, whereby those states that still have the death penalty must, without exception, exercise the most rigorous control for observance of judicial guarantees in these cases. It is obvious that the obligation to observe the right to information becomes all the more imperative here, given the exceptionally grave and irreparable nature of penalty that one sentenced to death could receive. If the due process of law, with all its rights and guarantees, must be respected regardless of the circumstances, then its observance becomes all the more important when the supreme entitlement that every human rights treaty and declaration recognizes and protects is at stake: the human life. Because the execution of the death penalty is irreversible, the strictest and most rigorous enforcement of judicial guarantees is required to the state, so that those guarantees are not violated and a human life not arbitrarily taken as a result. For the foregoing reason, the court concludes that non-observance of a detained foreign national's right to information recognized in 36(1)(b) of the Vienna Convention is prejudicial to the guarantees of due process of law. In such circumstances, imposition of the death penalty is a violation of a right not to be arbitrarily deprived of one's life in terms of the relevant provisions of the human rights treaties, and Article 4 of the ICCPR, Article 6, with the juridical consequences inherent in a violation of those natures, namely, that is, those pertaining to international responsibility of the state and the duty to make reparations. Adopting a similar approach, the Inter-American Commission on Human Rights has treated violation of Article 36(1)(b) of the Vienna Convention as a failure of due process. Illustratively, and Ramon therefore concludes that the state failed to inform Mr. Martinez Villarreal of his rights under Article 36(1)(b) of the Vienna Convention on Consular Relations, and likewise failed to inform the Mexican consulates of Martinez Villarreal's arrest and subsequent prosecution as required under that provision. These circumstances strongly suggest that the quality of due process afforded to Mr. Villarreal suffered as a consequence of his status as a foreign national, a circumstance that compliance with the notification requirements under 36(1)(b) of the Vienna Convention on Consular Relations may well have mitigated. The Commission also cannot find the standard of due process owing to Mr. Villarreal under the American Declaration and under the general principles of international law was satisfied based upon the state's contention in the matter as to the possible state of knowledge or involvement of Mexican consular officials. As to the Commission's competence in relation to Vienna Convention on Consular Relations, it was clearly determined in the merits decision in the matter that the Commission may properly consider the extent to which the state party to the Vienna Convention on Consular Relations has given effect to Article 36 of that treaty, insofar as these requirements constitute a part of the corpus juris gentium of international legal rules applicable in evaluating that state's respect for rights under the American Declaration. As the Commission concluded in the circumstances of Mr. Villarreal's complaint, non-compliance with the obligation under Article 36 can have a direct and deleterious effect on the quality of due process afforded to a defendant, and thereby call into question compliance with the requirements of Article 18 and 26 of the American Declaration, as well as similar provisions of other international human rights instruments. In Cesar Fierro and United States, the passage says in paragraph 30, and I quote, "The claim raised by the petitioners before the Commission is the contention that United States failed to inform Fierro of his arrest, of his right to consular notification, as provided in Article 36 of the Vienna Convention, as well as the correspondent customary international law and U.S. domestic law, and is thereby responsible for his violations of Mr. Fierro's rights under Article 2, 18, and 26 of the 26 of the Declaration. As described above, the petitioners argue that Mr. Fierro was precluded by August 4 and October 12, 1994 decisions of the Texas Court of Criminal Appeals for pursuing this claim before the Texas courts by limiting his proceedings to issues that did not include consular notification allegation, and that the U.S. federal courts precluded Mr. Fierro from raising claims based upon the limitations in the Anti-Terrorism and Effective Death Penalty Act. The judicial decisions on record before the Commission support the petitioner's contention. On that basis, the petitioners argue that Mr. Fierro should be considered to have exhausted domestic remedies available to him concerning his consular notification. Alternatively, he has been precluded from pursuing that claim. Based upon the foregoing, the Commission concludes that Mr. Fierro's right to information under 36(1)(b) of the Vienna Convention on Consular Relations constituted a fundamental component of due process standards to which he was entitled under Article 18 and Article 26 of the American Declaration, and that the state's failure to respect and ensure this obligation constituted serious violations of Mr. Fierro's rights to due process and to a fair trial under the provisions of the Declaration. Accordingly, should the state execute Mr. Fierro based upon the criminal proceedings of which he is presently convicted and sentenced, the Commission finds that this will constitute an arbitrary deprivation of Mr. Fierro's life, contrary to Article 1 of the Declaration. Upon considering the state's observations concerning the Commission's conclusions and recommendations, the Commission wishes to state that it is encouraged by the measures taken by the U.S. to enhance compliance with its obligations under the Vienna Convention on Consular Relations regarding consular notification and access. To this extent, the state appears to have taken some measures to implement the Commission's second recommendation reproduced below. At the same time, the Commission cannot accept the state's contention that a compliance with a foreign national's right to consular notification and assistance is irrelevant to the due process of fair trials under international human rights instruments, including the American Declaration. As the Commission has previously held, the fundamental due process protections, such as the right to prior notification in detail of charges against a defendant and the right to effective counsel, are of such a nature that in the absence of access to consular assistance, a foreign national could be placed at a considerable disadvantage in the context of a criminal proceeding taken against her or him by a state. Each case must be evaluated on its own individual circumstances. Once a failure to inform a foreign national of his right to consular notification and assistance has been proven, however, a formidable presumption of unfairness will arise unless it is established that the proceedings are fair, notwithstanding the failure of notification. While the state contends in the present case that the protections provided for in the legal system are amongst the strongest and the most expensive in the world, this does not foreclose situations in which access to consular assistance may have impact on the fairness of foreign nationals' criminal proceedings. This could arise, for example, in relation to a state's ability to gather mitigating evidence or other information from his or her home country. The history of the Medellin case presents an important example of significance of Article 36 vis-a-vis due process standards. In that case, the United States argued that the domestic law provides stringent due process protections not dependent on consular notification, access, or assistance, and that the guarantees under domestic law are amongst the strongest and most expansive in the world. Medellin had also moved the U.S. Supreme Court, and by its judgment of March 2008, the Supreme Court, though recognizing that the Avena judgments creates an international obligation on the part of the United States, held it does not constitute binding domestic law in the absence of implementing legislation, and on that basis declared unconstitutional the President's memorandum seeking to enforce the Avena. The IACHR nonetheless held that based upon the foregoing, the Commission concludes that the state's obligation under Article 36.1 of the Vienna Convention on Consular Relations to inform Mr. Mendel Ramirez Cardenas and Mr. Leal Garcia of their rights to consular notification and assistance constituted a fundamental component of due process standards to which they were entitled under Article 18 and 26 of the American Declaration, and that the state's failure to respect this obligation deprived them of a criminal process that satisfied the minimum standards of due process and a fair trial required under Article 18 and 26 of the Declaration. The Commission held that there had been a violation of Article 36, Para 1b of the Vienna Convention, and on that basis came to the conclusion that the imposition of death penalty in the instant case involves an arbitrary deprivation of life prohibited by Article 1. The IACHR issued a declaration that they vacate the death sentences imposed, provide the victims with an effective remedy which includes a new trial with equality, due process, and fair trial protection prescribed in Article 1, including the right to competent legal representation. This is extremely important. The evolution of jurisprudence of international law in this course has had the underpinnings of human rights in their broader dimension, for in the ultimate analysis, good relationship between the states, which make for conditions of peace and harmony, are conditions in which the human right to life, to live with dignity, and to enjoy those privileges so inherent to mankind are considered inviolable. Article 36, which crystallized into a multilateral treaty, a practice of the consular post, is concerned with human rights. In Avena, this court held whether or not the Vienna Convention rights are human rights is not a matter that this court need decide. But the decisions of the other fora, often relied upon as authoritative expostulation of the law, has identified in current times Article 36 as a part of the rubric of human rights. After the convention in '63, the principles of human rights were articulated in the ICCPR, and the states which have signed and ratified the treaty should be judged by the standards of the covenants of that multilateral treaty. India acceded to the ICCPR on 10th April '79. Pakistan signed the ICCPR on 17th April and ratified it on 25th June. The principles of the Vienna Convention can, in view of their widespread acceptance, now be characterized as obligations erga omnes. Where states have signed and ratified both Vienna Convention along with the optional protocol and the ICCPR, the rights under Article 14 of the ICCPR became inextricably interwoven. A breach of Article 36 would entail also a violation of Article 14 of the ICCPR. Although the violation of Article 14 may not be amenable to a remedy by itself in all cases, where the violation of Article 36 has resulted in a violation of, or the aggravation of the violation of, the rights under Article 14 of the ICCPR, the principles of state responsibility, as applied to the violation of Article 36 of the Vienna Convention, must recognize this synergy between Article 14 and Article 36, and must therefore address the serious consequences of the violation of Article 36, which results in the violation of or an aggravation of the violation of the rights under Article 14 of the ICCPR. Thus, the interplay between Article 36, the guarantees of the ICCPR, as well as the principles of due process as a minimum guaranteed human rights, would have a vital bearing on the fashioning of an appropriate remedy so as to achieve the desired aim of restitutio in integrum. Human rights and measures in diverse treaties that were fashioned to fulfill the fundamental promise of human dignity have to be considered in their confluent effect. And where the conduct of a states result in violating a web of principles, some derived from treaties, some founded on principles of international law binding on states erga omnes, the principles of state responsibility would have to be applied keeping in view the egregious nature of the violation of international law by the delinquent state, and not by the violation of individual treaties or obligations erga omnes. I now move to some defenses that Pakistan has sought to run. Pakistan cites commentaries from certain dissenting opinions or submissions made in certain cases where the word abuse or expression of good faith can be found. These phrases have been used in different contexts by different jurists, and each of the citations, apart from being non-authoritative, is irrelevant in the context of the present case. The heads on which Pakistan suggests that there has been an abuse, and I paraphrase them as follows. India's refusal to engage with Pakistan on its request for informing regarding the passport. India's allegedly furnishing Jadav with a false identity so as to facilitate his travel to Pakistan to commit acts of espionage and terrorism. India's assertion of treaty-based consular access rights in order to access an espionage agent. And India invoking provisional measures jurisdiction in the manner that it did, India having exercised its right as a tactical political weapon. Honorable President and Honorable Judges of the Court, I say none of these grounds bear scrutiny. Pakistan arrogates to itself the right to demand explanations from another sovereign country on wanton allegations made by it from time to time. These allegations have no role to play in the present proceedings, which relate solely to a violation of Article 36 of the Vienna Convention by Pakistan. The first and second grounds are rhetoric. The third ground suffers from the fallacy of circumlocution. If Article 36 grants rights of consular access in all cases, including where allegations of such kind are leveled, then demanding those rights cannot be an abuse of those very rights. Pakistan's challenge to India successfully invoking provisional measures jurisdiction, where after hearing both sides, this court by a fully reasoned order put in place such provisional measures, is, in my respectful submission, a mark of disrespect to this court. Professor Kulbhushan's authoritative commentary, the International Court of Justice identifies the notion of an abuse of process as the principle which is applicable both in international law and systems of municipal law. He described this as use by one or more of the parties of procedural instruments or rights for reasons that are fraudulent or designed to cause delay or simply frivolous. designed to harm the other side or give the abusing party an illegitimate advantage, intended to devalue other pending proceedings or deprive them of their object, intended purely for propaganda purposes, or generally for any purpose other than which the procedural rights concerned were instituted in the first place. Pakistan's conduct of attempting to play the doctored video in the court of the hearing and its overall conduct in the present case is using the platform of the present proceedings for propaganda. That, if anything, is an abuse. Professor Kolb goes on to say that such abuses simply cannot presume to have occurred, nor should they easily be considered to be proven. The states are sovereign, and accusations that there have been abuses should therefore be made only with great care. Also, the mere exercise of one's right should not be considered an abuse. This statement of the law shows Pakistan's argument on abuse is hopeless. The tone and tenor of the counter memorial, its disrespectful allegations and accusations against India on matters wholly alien to these proceedings show Pakistan, if at all, is abusing its right to defend itself in these proceedings. And finally, as Professor Kolb notices, the ICJ is frequently faced with allegations that procedural abuses have occurred. However, unlike other international tribunals, the court has not so far ever had actually to conclude that an abuse has been demonstrated. This restrictive approach by the court is desirable. Unquote. His words that, and I quote again, the practice shows that arguments to the effect that there has been a procedural abuse are themselves generally motivated by a most unwelcome wish to prevent the court from taking cognizance of a case by arguing for its inadmissibility in limine litis. These words have a resonance in the present case. Pakistan rightly understands that the role of this court is not a court of appeal from domestic criminal proceeding, but elsewhere it invites the court to examine the veracity of its allegations relating to the purported passport, which presumably would have featured in its criminal trial. Pakistan's case that India's refusal to, and I quote, provide explanations on a range of issues relating to the ongoing investigation, unquote, and its refusal to engage with Pakistan's mutual legal assistance request is a failure to act in good faith to the standard required by international law is, I submit, equally baseless. Pakistan does not dispute that there is no existing mutual legal assistance treaty, and that despite being repeatedly invited by India to enter such a treaty, it has declined to do so. The reason is not far to seek. There are a number of requests from India for legal assistance in cases of terrorism pending with it. Pakistan is driven to call to aid Article 2F of the UN Security Council resolution. In this context, India submits as under. First of all, it's ironical Pakistan relies on the resolution. The resolution begins by a decision that all states shall prevent and suppress financing of terrorist acts, refrain from providing any form of support, active or passive, to entities or persons involved in terrorist act, and take necessary steps to prevent the commission of terrorist act, deny safe haven to those who finance, plan, support, or commit terrorist acts. Pakistan's own conduct has been in breach of each of these elements. The assistance in connection with criminal investigations or criminal proceedings, including those relating to, and I quote, financing or support of terrorist acts, unquote, is achieved through entering of mutual legal assistance. I repeat, there is no MLAT between India and Pakistan. And it has been India's position all throughout that this is because of Pakistan's reluctance to enter into such a treaty. But even if there was such a treaty, the request made by Pakistan would not meet the requirements common to such treaties. It fails to provide any evidence or material that would prima facie establish the commission of an offense and for which investigation is necessary in India. An omnibus investigation into general allegations of espionage is not a serious action within the comports of criminal jurisprudence. A fundamental flaw in its request is it does not even mention the incidents in relation to which the allegations of indulging in subversive activities are being leveled. The premise of Pakistan's submissions is that Jadav had, and I quote, himself voluntarily and repeatedly confessed to financing and supporting terrorist acts, unquote. This, Honorable President, Honorable Judges, I may remind you, is the very confession that was aired even before the criminal justice system was set in motion by filing a first information report. This was for the ears of the international community. Pakistan alleges as a defense to India's case the principle of ex turpi causa, that is, the principle of illegality, unclean hands, and also the ex injuria jus non oritur. These allegations are hopeless. The factual foundation for these is same as the previous ground of defense of abuse. India reiterates its position. It is well settled that a party who has, by some illegal act, prevented another from fulfilling an obligation cannot demand the performance of correlative obligation. Pakistan distorts this principle to suggest that a prior illegal act has the consequence of negating any correlative obligation. An established illegal act by a state does not give license to another state to yet commit an illegality. A fortiori, far-fetched allegations of illegality, as are made by Pakistan in this case and from time to time, does not give it a license to sidestep and avoid its own international obligations. In relation to legal consequences of the construction of a wall in the occupied Palestinian territory, Pakistan relies on the separate opinion of Just El-Arabi, rendered in a completely different context. The context was the recognition of a territory, and the learned judge was of the view that illegal occupation of the territory should not be recognized. This is perhaps as irrelevant as most of the other material cited by them. Pakistan seeks to rely on a purported expert report as to the passport, which has been unilaterally obtained. India denies all these allegations, but I strongly submit these are also completely irrelevant and alien to the present proceedings. Pakistan's suggestion that the denial of consular access was on account of India's illegal activities seek to arrogate to states the rights to excuse themselves from any treaty obligation by making allegations, a proposition that has to be stated to be rejected. India, on its part, has always offered consular access to Pakistan, even when those arrested have been caught red-handed indulging in acts of terrorism. It is another matter that Pakistan has never availed of it. I now move to the next step of my submission, sir. I submit these facts therefore establish an egregious violation of Article 36 of the treaty. The three defenses which they run do not hold and should be rejected summarily. If I have established that, as a precursor to my submissions on what would be restitution in interregnum, it is necessary for me to show you what Pakistan military courts are all about. The military court that tried Jadav was established under the Pakistan Army Act in 52. In January 2015, Pakistan empowered military courts to try civilians for terrorism-related offenses. The Pakistan Constitution was amended, as were also amendments made to the Army Act 1952. This Honorable Tribunal would note that the genesis of Army Acts between the two neighboring countries is the same, the English law. But India has never amended or thought of amending its Army Act to allow the Army Court to try civilians. The court-martials are in Chapter 9 of 1952 Act. Jadav was tried by a field general court-martial established under Section 59 of the Army Act. Section 59 extends the jurisdiction of these army tribunals to civilians. In the present case, the Chief of Army Staff has confirmed the sentence of the FGCM. This was endorsed in a statement by Mr. Sartaj, as he is quoted above, even before Jadav could file an appeal. The working of the military courts in Pakistan had been censured by European Parliament. In a resolution of 15 June, the European Parliament stated, whereas military courts were authorized for 2 years while the civilian judiciary was supposed to be strengthened, whereas there has been little progress in developing the judiciary, and on 22nd March 17, military courts were controversially reinstated for a further 2-year period. The resolution states that the European Parliament deplores the use in Pakistan of courts that hold hearings in secret and have civilian jurisdiction. Says that the Pakistan authorities grant access to international observers and human rights organizations for purposes of monitoring the use of military courts. called also for an immediate and transparent transition to independent civilian courts in line with international standards on judicial proceedings. Underscores that the third country nationals must be allowed access to consular services and protections. This report was submitted to the International Commission of Jurists to the Human Rights Committee in its 118th session in Geneva. Some of the significant observations in their report are as follows. International standards clarify that the jurisdiction of military tribunals should be restricted solely to specifically military offenses committed by military personnel. They should not in general be used to try civilians or to try people for gross human rights violations. The draft principles governing the administration of justice through military tribunals, which were adopted by the UN Subcommission on the Promotion and Protection of Human Rights, affirm that the jurisdiction of military courts should be restricted to military personnel in relation to military offenses. The principles also emphasize the right to a fair trial, including a right to appeal to civilian courts, but also that a civilian is accused of a criminal offense of any nature shall be tried by civilian courts. International standards require that military courts, like all courts, must be independent, impartial, and competent, and must respect minimum guarantees of fairness, including those set out in Article 14 of ICCPR. Pakistani military courts are not independent, and the proceedings before them fall far short of national and international fair trial standards. Judges of military courts are military officers who are part of the executive branch of the government and do not enjoy independence from the military hierarchy. They are not required to have judicial or legal training or even a law degree, and they do not enjoy any security of tenure, which are prerequisites for judicial competence and independence. The Pakistan Army bars civilian courts from exercising appellate jurisdiction of decisions of courts. Civilian courts in Pakistan have held that they may use their extraordinary writ jurisdiction to hear cases relating to military courts, where any action or order of an authority relating to armed forces of Pakistan is either quorum non judice, mala fide, or without jurisdiction. Relying on this, Javed Iqbal Khori challenged his son's conviction and sentence on the ground of violation of a fair trial. However, on 27 January, the Lahore High Court dismissed his petition. The 3-page order of the court did not express specific concerns of the petitioner, including allegations of enforced disappearance. This case is currently pending in the Supreme Court. A second submission was made in advance of the examination of the initial report by the Commission to Human Rights in its 120th session in Geneva. Some of the significant observations in this report are as follows. Pakistan's system of military justice has placed the country in clear violation of its legal obligations and political commitments to respect the right to life, the right to a fair trial, and the independence and impartiality of the judiciary. In the 2 years since military courts were initially empowered to try civilians in connection with purported terrorism offenses, they have convicted 274 civilians, including possibly children, in opaque, secret proceedings. They have sentenced 161 civilians to death, and at least 48 civilians have been hanged after trials that are grossly unfair. In all these cases, the government and military authorities have failed to make public information about the time and place of trials, the specific charges against the defendants, as well as the judgments of the military courts, including the essential findings, legal reasoning, and evidence on which they are based. If I may just pause here for a minute, these words have resonance. We have not seen the evidence against Jadav. We have not seen the judgment of the military court. All we see is that doctored confession over and over again, apart from the passport and some expert report now we produce. At least 159 out of 168 civilians, 95%, whose convictions have been publicly acknowledged by the military, have allegedly, quote unquote, confessed to charges. In the absence of adequate safeguards and independent review mechanisms in the military proceedings, this very high rate of confessions raises serious questions about their voluntariness with respect to the infliction of torture and other ill treatment to extract confessions. States must ensure no one is held secretly in detention, whether in officially recognized detention facilities or elsewhere. The Human Rights Committee has made it clear that secret detention under the Covenant is itself prohibited, and the detainee should only be held in facilities officially acknowledged as places of detention. The UN Committee Against Torture has repeatedly stated people accused of a crime must be detained and interrogated in officially recognized places of detention. And the provision should also be made against incommunicado detention, where suspects are deprived of communication with the outside world. In its concluding observations on Pakistan, the CAT committee urged Pakistan to ensure no one is held in secret incommunicado detention elsewhere in its territory, as detaining individuals in such conditions constitutes per se a violation of the convention. However, suspects tried by military courts are often kept in secret detention, and family members, lawyers, and NGOs did not have access to them. Military proceedings were kept completely secret and closed to the public, and the right of appeal to the civilian courts was not available. Without any access to the outside world, the detainees were at a high risk of torture and ill-treatment. Family members of some of the people convicted by military courts petitioned the Supreme Court of Pakistan, challenging, amongst other things, the lawfulness and the voluntariness of the defendants' confessions. In August 2016, however, the Supreme Court dismissed all petitions without considering the allegations of torture and other ill treatment in any detail. The court reiterated the limitations of its review jurisdiction and noted that since the confessions were recorded by a magistrate and they were not retracted, they stood proved. The ICJ notes that the Supreme Court's treatment of questions regarding veracity and voluntariness of confessions in military trials is markedly different from its treatment of the same issues in the context of cases arising before civilian courts. Pakistani law and jurisprudence spanning decades clarify that in recording confessions, magistrates have to observe a number of mandatory precautions. The fundamental logic of the precautions, in the words of the Supreme Court, is to shed all signs of fear inculcated by the investigating agency in the mind of the accused and provide complete assurance to the accused that in case they are not making a confession voluntarily, they will be handed to the police. The Supreme Court has also held that confessions will have no legal or evidentiary worth if these directions are not followed. Procedures of military justice have made a complete mockery of these safeguards. Suspects were at all times in military custody even after the magistrate recorded their confessions. They had no access to the outside world, further compounding their vulnerability to external pressure and coercion. And reportedly, some of them were subjected to enforced disappearance by military authorities as far back as 2010 and kept at secret detention in internment centers in the federally administered tribal areas for many years before their trials. In such circumstances, confessions of accused before military courts raise serious questions about their voluntariness and over the legitimacy of the manner in which they were obtained, including concerns of torture and ill-treatment. It should be noted that Pakistani law, the scope of judicial review is severely limited. Courts have also interpreted review jurisdiction narrowly and have held that the High Court and its constitutional jurisdiction